I object to that. And you keep saying Mr. Idris, and I'm not Mr. Idris.
Who are you?
I'm the executor of the estate you're trying to administrate.
Do you know Mr. Idris?
I am the executor, and I'm here before the court
Is he-
on behalf of the surety of all the bonds. And I
How do you
appoint
know
you as
Mr.
the
Idris then? Tell me how you know Mr. Idris. How do you know
I
him?
am
How
the-
did he tell you to be his executor? How did you become the executor? How do you know him?
I have occupied the office of the executor. Everything is
My appellation is Shatina Grady L.
Okay. And Mr. Grady L., you want to tell us your name for the record?
My appellation is Daniel Grady L.
Okay. I mean, okay, I'll bite. That's fine with me. Appellation is a little unusual, but I'll go with it. So, Mr. Starr, let me interrupt you. I don't know why your client or Mr. Amadeo's client turned their video off, but this is the best we got with Zoom, so you can't elect to turn your video off during a hearing. Go ahead, sir.
I didn't turn my video off, Judge.
No, your client.
Oh, I apologize. I didn't know that.
The earlier case was the police had to act to not only break windows, but physically remove the defendant. So
I know who I am. I am the executor of the estate.
And he's not dead to the executor of the estate, or has he been found
I
not
am-
competent?
I am the executor of the estate. I am alive and breathing,
Okay.
and I'm
Alright.
competent.
Okay, good. All right. So I think all we have to do here is get you some court date. You've already posted bond, and we'll mail that out to you.
Did you? I just emailed the clerk of the court. I just emailed them the executor letter. I just want to know if they forwarded or not yet.
Okay. Well, it's in the court file, and I'm just setting you some trial dates, a confirmation date and jury trial dates to protect those rights.
Can I address the
Okay.
court?
Well,
I'm
that's
gonna-
all we got to do. You posted bond, and I've got other cases that I've got to hear in custody, and I wanted to save you from having to sit there for another couple hours. So I'm going to mail those to that Tukwila appeal box, and then you can take it from there as you've been representing yourself all along. And if you want to continue to do
I
that,
object.
that's fine.
I object to that. And you keep saying Mr. Idris, and I'm not Mr. Idris.
Who are you?
I'm the executor of the estate you're trying to administrate.
Do you know Mr. Idris?
I am the executor, and I'm here before the court.
Has he
as a
died? Has Mr. Idris died?
I came
I'm
on,
confused.
on behalf of the surety of all the bonds.
Do you know Mr. Idris?
I am before the court as a special restricted visitation and not general visitation.
Have you ever been known as Muhammad Ismail Idris?
Like I said, I am the executor of the estate, and I'm here on behalf of the surety of all the bonds. And I
How do you
appoint
know
you as
Mr.
the
Idris
trustee.
then? Tell me how you know Mr. Idris. How do you know
I
him?
am
How
the-
did he tell
I-
you to be his executor? How did you become the executor? How do you know him?
I have occupied the office of the executor. Everything is on the letter. I can read
Okay.
it to you.
So he told you you could be his executor? Did a court appoint you executor? Were you formally Mr. Idris? What? I'm just trying to
I know
understand.
who I am. I know who I am. I am the executor of the estate.
And he's not dead to the executor of the estate, or has he been
I
found not
am-
competent?
I am the executor of the estate. I am alive and breathing,
Okay.
and I'm
Alright.
competent. I'm competent, and I'm not a
Okay.
minor, and I am not the ward of the state, but I am
Got it.
part of the age of majority.
So Mr. Holcomb, is
My-
the
so-
state going forward with
So
the
my
charges?
question
wanna
to
know.
the prosecutor, my question
Well, I'll
to
let
the
you ask your own
prosecutor.
questions without me involved. But Mr. Holcomb, is the state going forward with the charges?
Yes, and I would request a
Okay.
warrant if Idris is not present.
Well, I think we've determined that, in fact, this is the person, but he would like to be addressed as the executor of the Muhammad Ismail Idris. And so that's all we're doing. We're going to mail you notice those court date, trial
I
dates
object.
set. I realize that. And then
I object.
you'll make decisions. I don't know what you're objecting to. I'm protecting all your rights. And you can talk to the prosecutor about settling this or not, or just go to trial on this. There you are. So I've got
I
other
ob- I
cases I've got to
object.
do. You can put that to writing and we'll hear what we can do about that. But right now, I just wanted to protect your trial rights and I'm going to move on to other cases. So we're done, Executor Muhammad Ismail Idris. So, and
I
Ms.
object.
Wally, Mr. Taylor.
Mr. Westmoreland, you ready to proceed with your client?
Yes, Your Honor.
And so we will go on the record in the matter of the city of Wyandotte versus Deborah Relitas, 221382. And appearance, counsel?
Attorney Corey Westmoreland, appearing on behalf of Deborah Relitas.
Thank you. Ma'am, your name, please. Ma'am, your name, please.
Motion state your name.
I didn't hear you.
Could you state your name?
Deborah Diane Browdy.
Realities. Okay. All right. And counsel, any objection to proceeding on Zoom?
Not at this time, Your Honor. We consent.
All right. And so today's the date scheduled for sentencing in this matter, and where your client pled no contest to disorderly conduct. And counsel, do you have an opportunity to review the recommendation with your client?
I did.
All right. And the court, after review of the recommendation and even recalling Ms. Relitas at the last court date, the court does find the recommendation is appropriate. And quite frankly, the behavior is that's alleged that Ms. Relitas pled not guilty or no contest to is absolutely reprehensible. Absolutely reprehensible. Whether you had to go to the bathroom or not, ma'am, there were many businesses you could have gone into and many porta johns you could have gone into. And to defecate on a public bench is absolutely reprehensible. The court is going to indicate that's going to adopt the recommendation. The court's going to indicate 90 days jail. You do get credit for the time you've been in custody, which is 13 days credit. And the court will indicate you are to be tethered to a treatment facility, mental health treatment facility. The court's going to weigh things and costs. Anything else?
Not this time, Judge.
Anything else, ma'am? I can't, it didn't come through, ma'am. What'd you say? Ms. Relitas, anything else? Ms. Relitas, anything else?
I can't even hear you.
Okay, well, so did you hear what the court indicated was your sentence? The court indicated that you're going to be sentenced to 90 days jail, credit for 13 days. You're to be tethered to a mental health treatment facility.
I spit on you.
Well, ma'am, right now that's not going to happen, nor are you going to do that to anybody over there at the facility, nor at the Wayne County Jail. You have some serious mental health issues, ma'am, and if you didn't hear me, I indicated that your conduct of defecating on a public bench was reprehensible. So that is the ruling of this court. The court's going to suspend fines and costs. Okay, ma'am, have a good day. Thank you.
Thank you, Judge.
Thank you. Thank you, Wayne County Jail.
513 FH and 21514 FH.
Are we going to do both of these together? I mean, they're the same motions from the people. They have slightly different fact patterns, and they have two different lawyers. So whatever you guys want to do, but what do you want to do?
There's no objection from Mrs. Grady L, Your Honor, to do them both together. It makes sense, I think.
Yes, Probia Star on behalf of Mr. Daniel Grady L. Yeah, no objection to doing this all together.
All right. And Mr. and Mrs. Grady L, can you hear us?
That's fine.
Yes.
All right. So let's start with, I guess, let me get the attorney appearances first. So Ms. Halapu, is this your appearance today? All right.
Yes, Your Honor. Good afternoon, Melissa Palico on behalf of the people.
All right. And we have Mr. Starr's appearance. Mr. Amadeo, your appearance.
Good afternoon, Your Honor. William Amadeo, P76194, on behalf of Shatina Grady L. We both appear via Zoom and waive a right to be present in person. And Judge, I do think Prosecutor Wint's on as well on this matter.
Thanks, Mr.
Oh, yes.
Amadeo.
Ms. Tucker is here. I'm sorry. Yes.
That's okay, Your Honor. Good afternoon, Your Honor. Assistant Attorney General Yasmin Tucker appearing on behalf of the people.
All right. Ms. Grady L., tell us your name for the record.
My appellation is Shatina Grady L.
Okay. And Mr. Grady L., you want to tell us your name for the record?
My appellation is Daniel Grady L.
Okay. I mean, okay, I'll bite. That's fine with me. Appellation is a little unusual, but I'll go with it. So, all right, today is the date and time set for the people's motions to admit, I guess, acts of prior motion, more 404B motions. So that's in the biz. Notice and a motion in limine to admit prior acts. I've had a chance to review the motions and the responses and the briefs. I'm happy to hear from either Ms. Palipu or Ms. Tucker. Highlights, again, you don't need to repeat, but I'm happy to hear your oral argument, and then I'll hear a response from Mr. Amadeo and from Mr. Starr. Okay?
Thank you, Your Honor. Your Honor, I'm not going to go back and repeat everything that I had previously written. You did have all the facts regarding the prior conduct, and you have my motion with all of the law. I would just like to make a little response in regards to the defendant's motions themselves. In regards to Mr. Daniel Grady L's motion response, I just wanted to also state that during that response, there was no statement of defendant's theory of the case in regarding in order to back his argument that these acts would not be relevant. In order to say that, you would need to state his theory of case to show that they are not relevant. And in fact, that there was no statement or theory of the case that was provided. I would just like to reiterate that the people do intend to admit this evidence to show that there was an absence of mistake or confusion as to what was occurring at the scene, or confusion of the officer's commands, that there was to demonstrate the intention to obstruct, which goes with the absence of the mistake or the confusion, and to rebut any argument of the defense to the contrary of those statements. In regards to my response to Ms. Shatina Grady L's response.
So let me interrupt.
Yes.
So while we're on Mr. Grady L's motion, I just want to be clear that the prior incident that you are seeking to have admitted is that 20 incident, correct?
Yes.
Because there's a slight difference between the two defendants. One is that Mr. Grady L is singularly that incident, while Ms. Grady L includes both the incident plus another one, correct? I just want to. Okay.
Yeah. Yes, right. Your Honor. It would just be that one incident for Mr.
So
Grady.
let's do this one at a time. So let's go ahead and I'll hear from Mr. Starr. If you wish to respond to what the prosecutor has just stated on the record or anything else, you may do so. But I have reviewed everything. So go ahead.
Yeah. So first is to my alleged facts. It's clear, and I do provide some basis here as to my client and why, if the 404B were allowed to come in, it would basically strip away what I'm alleging in my facts as to what occurred. But to put it simply and briefly, Your Honor, normally with the 404B motion, you're talking about a prior crime, a prior act, right? Here in this situation, from reading plaintiff's motion, they're not only speaking about a prior act, but also to defendant's alleged affiliation with an organization, and basically saying this affiliation with this organization is the reason why he is conforming to these responses with the police. 404B is plainly states that's not allowed. Evidence of other crimes, wrongs, or acts is not admissible to prove character of a person in order to show action in conformity therewith. they're speaking about things that are character evidence. They're saying, hey, he's acting in regards to how this more organization acts. But then on top of that,
Can I interrupt you,
yes, sir.
Mr. Starr? Let me interrupt you. I don't know why your client or Mr. Amadeo's client turned their video off, but this is the best we got with Zoom, so you can't elect to turn your video off during a hearing. Go ahead, sir.
I didn't turn my video off, Judge.
No, your client.
Oh, I apologize. I didn't know that.
Okay, go ahead, Mr. Starr.
Where was I? Oh yes, but then on top of that, they don't provide any type of substance, any type of materials, any type of literature or anything of that nature to show that yes, this organization does act in this regard when it comes to law enforcement. This is an assumption. As I stated, as I cited in one of the cases, this is character evidence masquerading as one of the exceptions. This is purely character evidence, and if it were to be omitted, this would violate my client's due process right to a fair trial, because it shifts the focus from the events of that night to, well, what are their beliefs, right? That's what we're talking about. What are their beliefs? Which again, plaintiffs are assuming their beliefs.
All right, Ms. Peliku or Ms. Tucker, anything to respond to that?
Your Honor, I would just indicate that my motion has absolutely nothing to do with their political beliefs, or I'm not really sure how to classify the organization, but that honestly, I believe they probably will bring that up themselves in trial. But that is not the focus of the argument. The argument is solely based upon that conduct that the police report was attached.
Okay. All right. And then since we have kind of argued that issue, I'm going to shift it now to Ms. Grady L. And again, there were two, I believe, there were two incidences in that question. So is there anything else you wish to comment there?
Your Honor, I'll just state the same thing, that the response to my motion did not provide any theory of the case or any explanation as to why this information would not be relevant. The people intend to utilize this information for the same purpose as previously stated, to show that there was an absence of mistake or confusion, and to show that there was the intention to obstruct the officers when going to that scene, and to rebut any argument from the defense to the contrary.
Okay. And Mr. Amadeo, any specific response for today's hearing?
Your Honor, you read our reply, and so did your staff, and I'll rest on that. I'll just add a couple things briefly. I don't know what the Attorney General means when there's no theory. This squarely rests on the Denson case. There's no striking similarity. In fact, the only similarity, Your Honor, is that my client's been a victim from 2 police agencies. I'll leave it at that. Thank you.
All right. So it's actually kind of hard for me to articulate exactly where I'm going with this. You're going to have to bear with me. In gross summary, I've reviewed all of the case law and the relevant rules of evidence and court rules on this issue. And so what the people are seeking to admit is evidence under MRE 404B that would allow a jury to hear prior criminal action or activity to essentially to show intent, absence of mistake or accident, or a system doing an act. It's somewhat limited to those purposes, and so I am cognizant both of Mr. Starr and Mr. Amadeo's arguments, but in looking at and that's why I was kind of trying to articulate the particulars of the differences between the two. So the 2 defendants share one incident that the people are seeking to admit prior evidence on, that being the March 9th incident, I believe, in the parking lot. And Mr. Amadeo, you bring up the question of striking similarity. And actually, I do find that there is striking similarity in what happened in that 2019 incident, as well as what is alleged in this case. I will note for the record that in the 2019 incident, there was a refusal on the part of the defendants to identify themselves, provide documentation. There was a refusal to cooperate with the police agency. Eerily similar family arriving and surrounding and videotaping the situation, and that allegedly in this case, in the current case, but what I believe was confirmed in the earlier case was the police had to act to not only break windows but physically remove the defendants. So I do find that that the evidence for March 2019, that incident in the Walmart parking lot, is admissible under 404B. It is not the finding.
The defense focuses on separating each incident, but the court is legally allowed to connect them. Once the judge recognizes a pattern, the case shifts from a single event to a repeated behavior, raising the risk that a jury interprets actions as intentional, not accidental.
In my analysis of this, that it is unduly prejudicial. I believe there are methods the defense can cure any potential undue prejudice with both jury instructions regarding the 404B evidence, as well as, yet to be determined examination and cross-examination of witnesses. So I believe that the defense has the mechanism to either cure or mitigate the potential for undue prejudice in this. I will grant the people's motion as to both defendants. I'm just going to call it the Walmart parking lot incident. The other interesting piece, though, is looking at Ms. Grady L's other instance. And so the people are seeking to admit evidence from a December high-speed chase. And while there are some similarities between the kind of the end result of that chase, I do find that under the Benson case that there is not a striking similarity, and that I am going to deny the people's motion as to that incident. So the ruling of the court, and so I will sign that order upon submission. Thank you.
Thank you, Your Honor. Have a good day.
Thank you. Well, hold on one second. Thank you, Your Honor.
Hold on one second.
Thanks.
Is this also a pretrial or just these motion hearings?
I thought it was also a pretrial.
I know. Hold on. Before I let you go,
Yeah.
Settle down. Let's get to my docket. All right. So we do have pretrials in both of these matters. I will tell both counsel that so you understand this, that I don't have fingerprints in either case. And, we can't continue. I don't know if there's going to be a trial in this matter. I don't know if there's going to be a plea in this matter, but I'm going to order that the fingerprints be taken care of before the next event, whether it's another pretrial, a final pretrial, or whatever that is. Otherwise, I'm going to need to remand your clients to get those prints done. So I'm just reporting that to you. I'm not going to remand them. That's not my intention. But just so that you know that we have to have the fingerprints done. Okay?
And, Your Honor, I'll get on top of that, but I believed when I called the sheriff's department, they were done, denied the arrest. I think they've been done another time. If they're not in your file,
Mr. Amadeo, this is a bit of a head scratcher. It's true. But the fact is everybody gets fingerprinted when they're arrested, but somehow the fingerprints don't get attached to the court file. And we can't proceed without the fingerprints being appropriately attached. So there's a fingerprint order. They can either go get re-fingerprinted, or you can figure out a way to get the prints from the sheriff's department into the court file, and we can do it. So you believe me, you're not the only one to say that, but I'm just letting you know we don't have them. So that's kind of where we are. And so I'm not going to set another event for next week. I'm not saying I'm going to remand your clients in a week, but what I'm just saying is we got to get that done. So what do you think, counsel, that the next step in this trial is? These are 21 cases. So we're at pretrial status, but my next step would be to set a final pretrial and a trial date. So is that where we are, or is there further activity that needs to happen?
We have some motions to file, Your Honor, but we could certainly do that before whatever your trial date is. and get a date from your court.
Yeah,
If we want to set a trial date for maybe March, I don't know what your docket is, Judge.
I mean, I don't know if March is kind of a random and arbitrary month, but it would certainly be in 2023. So January is a civil month, so it's as likely as not we might set we could set a trial date for late February, early March. That's fine. We'll do a final pretrial end of January, early February. Any motions obviously would need to be filed and heard on or before that final pretrial date. Okay.
And then, Your Honor, I just wanted to put the offers on the record if I could.
Sure, go ahead.
So I just got these offers, so I just emailed them to both defense counsels just like a moment before the hearing started. So they have not had time to process them or anything. But I just wanted to make sure that they were on the record. As for Mrs. Shatina Grady L., the offer for her is to plead to count 1, which is the R&O causing injury, and we would dismiss the remaining counts. I believe her guidelines would be 12 to 24. We would leave the sentencing in the court's discretion. As to Mr. Grady L., the offer would be to plead to a reduced count 1 to an attempted R&O, which would be a 1-year misdemeanor, and we would dismiss the remaining charge, and we would again leave sentencing in the court's discretion.
Okay. Counsel, you heard that, and you'll have a chance to discuss that with your clients, correct?
Correct, Your Honor.
Yeah, I received the prosecutor's email on that.
All right. So let's go ahead and set a final pretrial date for toward the end of January.
Let's do January 30th for final pretrial.
Okay, and then trial date would be end of February, early March kind of thing.
We could do February 27th or March 6th.
March 6th will work better for me.
All right.
Could we go
March
1 week
6th?
further? I'm in trial on March 6th and February 27th, Your Honor. I apologize. But
Okay.
March
All right.
13th.
So next one, the 13th, March 13th.
Yeah.
How does that
that would
work?
work well. That works for me, Judge, if that's acceptable.
That
All
works
right.
for the people.
All right. Good. So we'll set the trial date then for March 13th. That's 8:30 a.m. Monday for jury selection. And we will see you at the final pretrial, or if there are other motions to be filed, you don't have to wait till that final pretrial date, but that's the next court event. Okay. So I need to have the prints done by the final pretrial. And I did just check while we were on the hearing, they weren't printed. The sheriff's department does not have fingerprints for them. So that's going to need to happen.
Okay.
All right.
I was told differently. I apologize, but I'll get on top of that.
No,
Judge.
I'm not, I wasn't there, but I'm just letting you know what we know. So, okay. Thank you.
All right, thank you, Your Honor.
Yep.
Across both cases, the pattern isn't emotional, it's procedural. In the first case, the defendant attempts to separate identity from legal responsibility using sovereign citizen language. Executive of the estate, special appearance, not the person. But courts operate on physical presence and jurisdiction, not self-declared status. That mismatch creates a silent consequence. The court proceeds as if the argument was never made. In the second case, the issue shifts from identity to strategy. The defendants introduce language like appellation and challenge the framing of evidence, while the court focuses on admissibility under rules like Rule 404B. The judge's decision shows something critical. Prior behavior can legally shape how a jury interprets intent, even if the defense tries to isolate each event. What connects both situations is a misunderstanding of where control actually exists. The defendants focus on redefining identity or narrative. The court focuses on procedure, evidence, and compliance. And that gap has consequences. Ignoring court structure doesn't pause the process. It removes your influence inside it. Challenging identity doesn't eliminate jurisdiction. It just avoids engaging with it. By the time trial dates are set and evidence is admitted, the window for strategic decisions has already narrowed. In court, outcomes aren't driven by what someone believes the system should recognize, but by what the system is legally required to process. And once that process starts moving forward, it rarely slows down for anyone, or